Joining us. Thanks for joining us for another GIA lunchtime CPD. Before I introduce our speakers, I just quickly go through some housekeeping rules. So please keep your cameras and mics off just to spare some bandwidth. And if you have any questions, you can put them in the chat box at any time and we'll just read them out after the presentations. There will be a recording of this meeting and this will be made available on our website afterwards. So if you've missed anything or want to go back to something, you can just have a look at that. So today, topic is time bar on claims relating to design defects. And we have Stephanie Clark, who is an associate at Brody's LLP Solicitors, and Manus Quick, who is a partner. And I will be doing a joint presentation, and I just hand over to Stephanie just now. Thank you.
Okay. Thank you very much, Karen. Good afternoon, everyone. Thank you very much for joining. So as Karen mentioned, the topic for discussion today is the Scots law on time bar, and specifically how that applies to claims relating to design defects. So the purpose of delivering this topic today was because kind of the law in this area has undergone some quite drastic changes in the past few years, and the claims that we see coming across our desks in relation to design defects have really had a focus now on time bar. So we thought that it was important to give you all as designers an overview of what the current law means, just so that you have a grasp of that if you find yourself in the unfortunate situation and having to deal with a claim for alleged design defects. So in terms of an overview of the talk today, I'll start off by going through what prescription is. So by prescription, we effectively mean time bar. So I'll look at that in a bit more detail and why it's important. Then I'll go on to discuss short negative prescription, which is the type of prescription that we most commonly deal with, which is your 5-year time bar period, and the recent case law that I mentioned that kind of changed our understanding of that area. And then my colleague Manus will pick up on what attempts have been made to effectively avoid the impact of the recent case law on this, because as we'll come on to discuss, it's fairly harsh in terms of those who are looking to raise claims. And then Manus will also cover off long negative prescription, which is the 20-year period to raise an action. Kind of less commonly does that come up as an issue, but for completeness, we've included it in the talk today. And then we'll go on to discuss the extent to which you can provide for prescription in your appointment agreements. And then finally, given that the topic of conversation today is suing designers, we thought it would be useful to go through some kind of common contractual limitation clauses and how you can include these in your appointment agreements to effectively limit your exposure for claims. So looking in a bit more detail at what prescription actually is. So as I mentioned, prescription is also referred to as kind of time bar. What prescription does is it covers a multitude of different rights and obligations and when those can be enforced. But in the construction industry, we're generally concerned with the obligation to pay damages for either breach of contract or breach of a delictual duty. So for those of you that haven't come across this before, delictual duties are effectively duty owed to clients out with a contract. So just because you've not entered into a contract with a client doesn't mean you don't owe them duties under law, and prescription covers those duties just as they would a breach of contract claim. And prescription specifically is the time period during which an obligation to pay damages for breach is enforceable. And by damages, we just generally mean recompense for a wrongdoing. So if after that time bar period, the obligation hasn't been raised by way of a relevant claim, which I'll go on to discuss, it's effectively gone forever, it's extinguished. And when we talk about a claim having prescribed, we mean a claim's time barred. And the specific piece of legislation in Scotland that covers prescription is the Prescription and Limitation Scotland Act 1973. Now that is soon to be amended by the Prescription Scotland Act 2018, which Manus will touch on, but it's not yet in force. So for current purposes, we're dealing with the 1973 Act. So looking at that Act in more detail, the two sections that we're concerned with when we're looking at this short negative prescription 5-year time bar period are sections 6 and 11. So what section 6 tells us is that if after the appropriate date, an obligation to which that section applies has subsisted for a continuous period of 5 years without a relevant claim having been made or without the obligation having been relevantly acknowledged, which I'll discuss in the next slide, then after the expiration of that period, the obligation will be extinguished. So the question that follows from that is, what is the appropriate date? What is it that's going to trigger this 5-year time bar period? And for obligations to pay damages for breach of contract or delictual duties, you're looking at section 11. And section 11.1 provides that the obligation to pay damages becomes enforceable on the date when the loss, injury or damage actually occurs. Now, the legislators recognised that the creditor, which is the kind of term given to effectively the person that's been wronged for the purposes of that Act, they're not necessarily going to always know that they've suffered a loss on the date when the loss has occurred. For all manner of reasons, it could be the case that they don't discover that loss until much later on. So what the Act does at section 11.3 is it will postpone the date for the time bar period starting to a date when the creditor actually becomes aware that they've suffered a loss, or with reasonable diligence could have become aware. So reasonable diligence wording is in here, as you can imagine, just to add a bit of objectivity to when the trigger starts, because otherwise you could be in a scenario where the creditor delays kind of unnecessarily in investigating their claim, isn't particularly proactive in terms of determining when their loss has actually occurred. So the reasonable diligence is added in there just to give an element of objectivity. So moving on then to discuss what actually will interrupt prescription once the creditor becomes aware that they've suffered a loss. What they then have to do to effectively stop that 5-year time bar period clock from running is raise a relevant claim. And for the purposes of the Act, a relevant claim means either raising and serving a court action or raising an arbitration. Now, more commonly, creditors are going to raise and serve a court action. And the reason for that is it takes a bit longer to get an arbitration to a point that it needs to be considered a relevant claim. So more often than not, you're going to find that a court action is raised in order to interrupt time bar. So that's why you might hear language like time bar summons or time bar writs being served. And then another way that you can interrupt prescription is if there's effectively been a relevant acknowledgement of the breach that has caused the loss, which really just means the wrongdoer effectively admitting liability. So as you can imagine, that's going to be a rare occurrence, because when there's rumblings in a project about there being a workmanship or a design defect, lawyers will get involved, PI insurers will get involved. So it's unlikely that you're going to get an admission of liability there. But even if the lawyers and the insurers come in a bit late and there might have been discussions in the project about the issue and there's potentially been an admission of liability, the creditor probably isn't going to rely on that as interrupting time bar, because arguments could be made later on that it shouldn't be construed as an admission of liability. So chances are they're going to raise a court action anyway, just to protect their position and be cautious. So looking in a bit more detail at section 11.3, so this part of the Act is commonly used when it comes to construction claims for design defects. Reason for that being is more often than not, design defects only manifest themselves much later after the breach has occurred, known as latent damage then becoming patent. So for construction lawyers, section 11.3 was used to effectively postpone the start of the 5-year clock ticking to a point where the building owner or the employer actually became aware that there's been a design defect and that's manifested itself as a loss. And there was a particular Supreme Court case that looked at how that applied in more detail. So that was Morrison's against ICL Plastics. and that concerned the explosion of a plastics factory in Maryhill. And the pursuer in that case was a local shopkeeper whose shop was damaged from that factory exploding. So they sought to raise a claim against the factory owners for damages as a result. And the factory owners argued that the claim had time barred. And what the shopkeeper had said as well, I only knew about my loss when I knew that the factory was actually at fault for causing that explosion, and I knew that those were the ones to sue to recover my loss. But what the factory owners argued was that, well, no, you knew you'd suffered a loss when your shop had actually been damaged by the explosion. So the 5-year time bar period started then. And the court agreed with the factory owners in that circumstance. They were very clear that loss for the purposes of Section 11.3 is factual awareness of a loss. It doesn't require there to be an investigation into the reasons behind that loss actually occurring and knowing who to sue. And albeit the only way you can interrupt, or one of the only ways you can interrupt prescription, is actually suing a party, and you might not know when you've suffered a loss who that party is, the court had said, well, you've got 5 years to work it out, so that should be ample time. And I think what the court are trying to do here is effectively balance the interests of both parties. So if you had a situation where the time bar period didn't start until the pursuer had been aware that they'd suffered a loss, they carried out investigations, they knew who was at fault, that could go on for a considerable amount of time. Meanwhile, the defenders potentially lost records that would help them defend that claim. Memories will fade. They're not going to be in a position to be able to defend the action as effectively. So it's just all about balancing the interests of both parties when dealing with these claims. So Section 11.3 came before the court again in Gordon's Trustees against Campbell, Riddle, Breeze, Patterson. Now, this claim related to a professional negligence action against a firm of solicitors for failing to serve a notice to quit on tenants on time. And the defenders had argued that their clients had effectively raised the claim out with the time bar period. And the reason for that was because the defenders were looking to argue that the pursuers in that case couldn't rely on knowledge of their loss being some sense of something having gone wrong or something having gone awry. What it is just based on Morrison's against ICL Plastics factual awareness of a loss. And the court agreed with the defenders' arguments in that case. And as you'll see on the excerpts on the slides there, they went as far as to say that loss could just be incurring expenditure that perhaps only with the benefit of hindsight you realise has been wasted. So as you can imagine, that's a fairly harsh result for creditors, those looking to raise claims, because it's not always the case that when you spend money on something that you realise that you've not got what you've bargained for. You could be spending money thinking you're getting some benefit in return. But the court had said that the whole point of Morrison's against ICL was to make sure that we didn't need to expect pursuers to have factual awareness of what's caused their loss. There needs to be a more objective viewpoint with this. So that case caused a bit of nervousness among litigation lawyers, particularly where you're going to have cases where loss might have been suffered, but you're not going to know until much later on that it's actually been as a result of something going wrong. And it just means that that 5-year time bar clock's running short. And it could be the case in some instances that the pursuer isn't aware that their claim's actually time barred until after it has already time barred. But that case was a professional negligence case against a firm of solicitors. It wasn't a construction case. Construction cases do have commonly latent damage as being the cause of loss and damage not manifesting itself until much later. So we were all waiting to see how the courts would apply this in a construction scenario. So that case came about in 2019, and that was Midlothian Council against Blythe and Blythe. and that concerned the design and construction of a housing development on behalf of Midlothian Council. And the development was built without a gas membrane being installed in reliance upon negligent advice from the professional team. So that problem, though, wasn't realised until the 7th September 2013, when dangerous CO2 levels were recorded on site. So that resulted in the site being completely demolished and rebuilt, and the council raised a court action in September 2018 to recover the losses associated with that, which was within 5 years of the problem being reported on site with these dangerous CO2 levels. But what the defenders argued is they said that your loss wasn't discovered in September 2013. Your loss was actually occurred much earlier on, when you spent money in furtherance of this housing development that was effectively based on negligent advice. It was doomed to fail, because based on what the court was saying in Gordon's Trustees, your loss can just be incurring expenditure. And the court was very clear that that expenditure could be the case that with the benefit of hindsight that it was wasted, but you don't need to have that knowledge at the time. And unfortunately for the council, the court agreed with the defender's argument in that case. They recognised that it was harsh, but they said that we need to have an objective understanding of when loss actually occurs and the 5-year time bar period is triggered. So we thought after Midlothian Council was issued that subsequent courts wouldn't apply it, because, as I said, you can have this what seems an unjustified situation whereby employers, building owners, their claims are time barred without them even knowing it. And in fact, there was a Sheriff Court decision that was a construction claim a year later that found that Midlothian wasn't correct, and they chose not to follow it in that case. And the Sheriff kind of issued a decision based on what everyone had understood loss meant for the purposes of Section 11.3, you know, something having gone wrong, not just spending money. And that gave us some hope that the law might regularise in this area. But then this topic came back before the Court of Session with the case of Glasgow City Council against VFS Financial Services. And the judge in that case considered that Midlothian was right, the Sheriff Court had got it wrong, and that what Midlothian had done was just followed the Supreme Court and Gordon's Trustees, and that's all that it could do, given that it was a higher court. So although as designers you might be thinking, this is favourable to us, we're in a situation where it's going to be more difficult to be sued successfully because we might have more time bar arguments being successfully run in these cases. But as Manus will go on to discuss, there's been arguments arising trying to effectively avoid the implications of Midlothian and the effects of that. So I'll pass over to Manus, pick up on this.
Thanks very much. So if you're to summarise where we are at the minute, the law never changed. The law was always set out in the Act. It was how the courts interpreted loss that was a significant change in all of this, and therefore by the extrapolation where the starting date or the date whenever loss was incurred. And where we are today, Stephanie has outlined to you how we got to this position, is that we have maybe 2 or 3 legal decisions that set out how the law is currently being interpreted, but very few cases where it has subsequently been applied that will refine it. So all advice that we have to give in relation to time bar and prescription, time bar being the English equivalent word, but prescript is more commonly used, but it's prescription in Scotland, is always qualified with, we don't know how the courts are going to interpret this longer term, but here is what we know for now. What we know for now is that in relation to design, the client suffers the loss when they expend monies in furthering a design that was always doomed to fail, if you want to put it in layman's terms, and it was always doomed to fail. Monies was spent on it. Think of Midlothian, the building of houses on top of what should have had a land that should have had a gas membrane. They suffered loss. You may not know you've suffered a loss at that time, but one of the commentaries in Midlothian Council, one of the commentaries by the judge says there are situations where the claim will have time bar before the client ever knows it suffered a loss. but that is the price of certainty. And the reason for that is that the courts didn't like the way the law was developing. And there was a case called RBS against Halcrow, where, and there was a case that we had some involvement in latterly, where formwork had been removed from a building too early, and the floor started to bow to banana. And the question was, at what time had that claim potentially prescribed? And it was decided that, and I'd seen the photographs of the condition of the floor at the time whenever the courts decided that the clock had started to run on prescription. And they were very, very bowed at that stage. And it was decided at that point in time that it was the point in time whenever the subsequent engineers advising the client told them, you have a problem with progressive movement. And that was what the courts didn't like. It was whenever that degree of subjectivity came into it, that they decided that the law needed certainty, even if that was going to produce some very harsh consequences. So it's from the date whenever the client entered into a contract and expended monies based on a design that was always doomed to fail. That's your soundbite to take from this. As you can imagine, whenever you've got a situation as harsh as that, with the consequences that can be as significant in terms of damages that are no longer recoverable. There have been attempts to try and find a way around that, to try and apply the law, to try and save claims that would otherwise perhaps have been time barred. And there's 2 or 3 ways in which that's happened. And the first is the application of 6.4 of the 73 Act. And that effectively, that's whenever you're counting your 5 years, so the date still starts at exactly the same date, the date of loss. It's any period during which the innocent party is induced to refrain from making a claim by the wrongdoer or someone on their behalf's words or conduct is discounted. So effectively, stripping through that, if there's a period where you as a client have been led to believe that everything's okay by words or conduct, that period is excluded from the counting. And the argument is that the designer perhaps has issued a certificate. We've seen arguments as well around, that they have submitted invoices to the client and not said anything, and the client has paid those invoices. And there's a third bullet point, words or conduct. That can be active or passive, and it may involve positive action, but equally in certain circumstances, it may involve a silence or a lack of action. That's from Heather Capital case, but fundamentally, it's being able to demonstrate and demonstrate that had you told me, you had every chance to tell me that your design was wrong and that I was going to suffer a loss, and you didn't say anything. The courts will generally exclude those periods from the counting of the 5 years. Loreto Housing Association is one of the few cases we've had in all of this since Midlothian. And that the pursuer claimed that the contract works had been passed off as being compliant with the requirements of the contract. And therefore, on that basis, the client was induced to refrain from making a claim. Now, this was just an interim hearing in that case. And if the law had been that what the designer in that case had done was not inducing if it wasn't a valid argument, then the case would have been kicked out, and the case wasn't kicked out, which means that this argument is still alive. It's still a competent argument to raise. Could I have the next slide, please? So in short, if you, by your act or conduct, do something which leads the client to believe that everything's okay, that can be discounted from the 5-year period. Now, that's different from workmanship. Remember, this is all design, and what the output of all of this is that claims for design will time bar generally at a different point in time than workmanship, and generally much earlier in reality. And this is Agro Invest against Stuart Mill, which is another one of our cases. And that it was alleged that issues relating to water ingress were caused by the contractor's failure to carry out the works in a proper and workmanlike manner. And during 2008, water ingress became apparent. The building PC'd in 2nd of December 2010, so 2 years later. Not uncommon to have defects before PC. The court action was served on the 24th of April 2015. So the contractor argued that the loss was suffered when the water ingress became apparent, and so the claim time barred around about 2013, and you can see the logic in that. The court found the contractor had a dual obligation to carry out and complete the works, as most standard form contracts will say. And therefore, the point at which to assess whether this obligation has been met can only be at practical completion when the works are handed over. So in relation to workmanship, and this is generally the understood principle, is that The works can be not in accordance with the contract up to PC, but that's classified as temporary disconformity, i.e. I haven't quite finished yet, I'll get back to it and I'll fix it. But then at PC is the date whenever you would generally assess whether or not there's been compliance. And that's generally the date at which there's a breach of contract on the part of the contractor when they hand the building over to the client as practically complete. And that is why equally you will find that a lot of court actions are raised just immediately before 5 years from PC. And that's on the principle that you handed the building over in a defective state. So it's a different date from the date of loss in relation to design. And remember, it's not just design, I would say, it is design, it is advice, it is specification, it is all of your professional obligations, performance of your professional obligations. If you think about Gordon's trustees, it was about legal services, but it's any of your services, not just design, but generally it will be design/specification. Can I have the next slide, please? The new law, and there is a new, as Stephanie has said, there is new legislation coming out, and it's probably is long overdue in relation to prescription, but it doesn't fix anything insofar as the way the twists and turns that we're seeing arising out of Midlothian. And that is 11.3 is being amended, and that is the with reasonable diligence. Now, it used to be you would just off pat said, yeah, the obligation prescribes, the obligation to pay damages prescribes 5 years from the date of the breach, or 5 years from the date when, with reasonable diligence, you could have been aware that there was a breach. When could I have reasonably known about it? And that's his arguments such as, show me your repair, your maintenance records. You should have seen that much earlier. That's the type of arguments that we've been running for years. And particularly it comes to latent defects. You should have known about that if you had been competently inspecting your building, as you had an obligation to do much earlier, and therefore your obligation is time barred. Standard arguments in latent defect type projects, disputes, sorry. Now 3A there that you see the changes that they're proposing to make to that legislation, and it's the facts that rely upon is that the loss, injury or damage has occurred, that the loss, injury or damage was caused by a person's act or omission, and the identity of the person. So you got to know all of those. Now it does change things, if you can imagine it, because it didn't really, if you think back to the decision and the Stockwell case that we with ICL Plastics, it didn't matter. That whole point was it doesn't matter if you don't know. And what happened there, if something you may remember, is that the families waited until the outcome of the public inquiry before when wrongdoing was found, and that to then raise their court action, by which time it's too late, because the court says, because the law said it doesn't matter whether or not if you know you suffered a loss, it doesn't matter that you don't know who's actually caused it. So that is being addressed, but the point is that it doesn't address the difficulties posed by how you categorize loss, i.e. wasted expenditure. So the law, Midlothian will not be changed, will not be impacted by the new legislation. Can we, the next slide? Long negative prescription is interesting. So remember, the principle is that you shouldn't be on the hook for the consequences of your failures, of your breaches, of your shortcomings indefinitely for all time. And there's a point in time at which the law says that you are no longer liable for the consequences of your own failings. And that's generally 20 years, or I think it's from memory 15 if you're in England, the Latent Damages Act. So 20 years. So at any point in time within that 20-year period, and it's based around this, when with reasonable diligence could have been aware. An idea is that if a latent defect arises that you couldn't have known anything about before, you will then have 5 years from the date when you could have been aware, you should have been aware of the defect. So the sliding scale within an overall 20-year period at which effectively the axe drops and your liability comes to an end. How does that work after Midlothian? The answer is we're not completely clear, because the decision in Midlothian itself, 11.3, remember, is that when with reasonable diligence you could have been aware, which is the whole principle of latent defects. When could you have known about it? The answer is the judgment does say there still is a place for 11.3. We just don't know, we can't work out what it is, because effectively you take that principle that from the moment you enter into a contract, or you expend monies on a design that was always doomed to fail, it doesn't really matter if it's going to fail within the first 5 years or 10 years or 15 years. If the clock starts, if you incur your loss at the time of that wasted expenditure, then it's going to time bar 5 years from the date of that loss. So it's not as if there's two separate rules here. There is only one rule with effectively a long stop. So for the obligation to pay damages, the period begins to run from when the obligation becomes enforceable, as we say. 11.3, it doesn't, the reasonable diligence doesn't apply to long negative prescription. So the innocent party cannot use their knowledge of when the loss was incurred to delay the start of the 20-year period. Yeah, it starts effectively from the breach, as we say. And Midlothian largely means the long negative prescription is possibly redundant for design defect cases because of the 5 20-year periods are triggered from the same point. What that means is the loss is incurred when monies are expended. And if it's still applicable in relation to the latent workmanship defects, so it's always going to be, that is true. This is workmanship, the same principles apply as before. The 20-year period would run from PC. Next slide. Right, can you contract out of it? And this is where it's interesting, because a lot of the mistakes that we have seen made in relation to prescription are because everybody assumes the law is the same in Scotland as it is in England. Now, for example, we've recently been consulted on a case where the solicitors rang up and said, this is the same as, the law is the same as in England, isn't it? And you went, no, it's 6 years. No, it's 5 years. And it was already too late. The claim had potentially, may potentially have gone by that stage. We've seen that. We've seen, can we enter into a standstill agreement, please? No, they're not recognised in Scots law. So the things that you can't do in Scotland that you can in England, the law is just different, fundamentally different. So the parties can only agree to reduce a period for raising a claim. You can't extend it. So for example, if you go to buy a house, your missives are only enforceable for 2 years and not the 5. So it's competent for you to contractually, what you're saying is that you and I, between us, have entered into a contract and we agree that we will not enforce our respective obligations after 2 years. Okay, the law gives us 5, but we, between us, have agreed that we're only going to enforce them for 2. And the other place where you'll see that quite often is the PFI projects. And that commonly reduces long prescription to 12 years from PC. 12 years, where that comes from is in England, and again, you can't do this in Scotland, there's 2 ways in which you can enter. You can execute a contract in England. You can execute it underhand, in which case you've got your 6-year time bar period, which is equivalent to the 5 in Scotland, or execute it as a deed. You probably heard the term execute, describing deeds. Deeds don't exist in Scotland. And there's just slightly different special rules for how you execute a deed, which means that it's enforceable for a 12-year period. And that's where the 12 years comes from. So PFI projects commonly reduce the long negative prescription period. So the 20-year date gets reduced to 12, and that is backed up by 12 years worth of insurance cover. But that's where that comes from. The parties have agreed that, and it's become standard. Standstill agreements are valid in England, but not in Scotland. Standstill agreement is, I agree that this claim will time bar if you and I don't enter into a contract, but between us, we agree that we'll keep it alive for another year, and then you just keep extending it year on year. 2018 Act, this is the changes to the new law of prescription in Scotland, will permit them if they're entered into after the prescriptive period has started, so you can't do it in advance of the clock starting, but for no more of the year and for one occasion only. So there's some limited scope to enter into those, but that act isn't enforced yet. So it's still, key message in Scotland is 5 years, not 6, and you can't say, you can't, the only way to stop the clock is by either a relevant claim or relevant admission. And in reality, relevant admissions don't rely on them. Just raise your court action, serve it, and that stops the clock. And then everybody is, you've got certainty, which is what this is all about. It's about preserving claims. And I know that you will all be designers and you're saying, why are you giving me this advice whenever the claims would be against me? Remember, there may be that you could be backing this claim off to another party that perhaps provided some of the specialist elements of design to you. Contractual limitations, right? The reason we put this slide in here is because it'll become apparent. What we're building up to here is, if you keep the fundamentals in your head, it's design, specification, advice. It's going to be from the date of loss is the date when someone that enters into a contract. Effectively, incurs wasted expenditure in reliance upon your defective design. But the things that you put in your contract can actually help your position a bit as well, because remember, there will be design, but there'll also be workmanship issues, and there will be you will have inspection obligations if you're a contract administrator. So therefore you do share some of the risk in relation to workmanship issues as well. So it's not all just about design and specification. So what can you do in your contract, or what should you be doing in your contract to try and restrict the scope of your exposure? Well, first of all, you can contractually agree, as we've said, to reduce time limit for making a claim. So parties agree that we'll only be liable for 5 years on PC, 10 years, 12 years, whatever you agree. But you can shorten your overall time, your period of liability. You can cap the amount of the liability, and that can be in line with, it says here must be in line with designers. I think that's not correct. It can be whatever you agree. I've seen it agreed at. I've seen it agreed in line with your PI cover. I've seen you in line with the fee, a multiple of the fee. There's so many ways in which you can do it, and it's just a question of what you can negotiate. Exclusions of certain types of liability, and that's going to be, for example, it's quite often the exclusions are to do with either what you can get insurance cover for, which is why fire performance of cladding would be one that perhaps excluded, or asbestos, or it can be that you're trying to reduce the scope of what you could be held liable for to more direct losses only. So consequential losses, business interruption, loss of rent, all of those types of things are common exclusions from liability. So you're trying to reduce the scope of your exposure. And exclusion of some project-specific risks, such as contaminated ground or working around existing buildings. It's just the principle is that you should be thinking anyway in your appointment about how you can restrict the scope of your obligations. And net contribution clauses is the one I was really coming to, because that's the one that's probably of most relevance to all of this. A net contribution clause is the basic principle in Scots law is that you are joint and severally liable for any losses that you cause or contribute to. So if you contribute to a loss, you can be sued for 100% of the consequences, even though your contribution is only 5%. And if you want a good example of that, if you take the inspection obligations, you certify those works as being having been carried out properly in accordance with the contract. So therefore you contributed to the problem. You should have identified those works as defective, and that's something that those of you in practice will recognize as a complaint. So are you going to get sued? So the contractor goes bust. And RBS Halcro, the case I talked about, was because Lilly had gone bust. Halcro had been pursued for all of the loss, even though the majority of it was workmanship that Lilly were responsible for. So if you're last man standing, you're getting sued for 100% of the loss. A net contribution clause says you will only sue me for the proportion of the loss that I actually caused. So if you were to take, for example, inspection obligations, I've seen arguments that an inspection obligation only is worth maybe about 10%. It was only causes about 10%, because fundamentally you're not relieving the contractor of the consequences of their own defective workmanship. It's just something that you should perhaps have identified during your inspection obligations. And I'm using inspection carefully because, it's not supervision, unless you've signed up to supervision, which is a whole different animal, but that doesn't really happen very often. So in terms of your inspection obligations, so you can see the distinction. There's a distinction between being sued for 100% of the loss and being sued for 10% of the loss. Now, I've seen Cat 3 checks by engineers on infrastructure projects where, because you're in effect redoing the design as part of the check, we've seen up to a 50% contribution, but generally around about the 10-20 for a designer. So the message in this slide is, against the background where we've told you what the law is on time bar, against the background where workmanship will prescribe later, it'll be generally 5 years from PC, which is a completely different period. Your design obligations can have prescribed far, far earlier than your inspection obligations, but you could still be sued for the whole thing, because effectively if you have caused or contributed to the whole loss, you can be sued for 100% of the loss, which is why this slide is particularly important. And so in terms of summary, I've already said the design obligations will prescribe, generally will prescribe earlier than inspection obligations. Joint and several liability means that if you can contribute to the failure, you can be sued for all of it. And even if design obligations are prescribed and you fail in your inspection obligations, you can be sued for all of the loss. And that's why it's so important to have net contribution clauses. And to the extent that they help as well, some sort of contractual limitation of liability. Now that's in a perfect world, you'd be able to negotiate all of these. In reality, it'll just depend on what the market will allow you to negotiate at any one point in time. And the stronger the position that the client is and the less that they need you and your particular skill set, then the less likely you are to be able to negotiate these. But the market goes in cycles, and there are times when these are much easier to negotiate than others. So I think that's us. We've covered the entire talk. If anyone got any questions, anyone got a friend with a problem, is quite often what we get at this stage. Right, first question. For what reason might the affected party wait so long to raise a claim? Specifically in the case of Midlothian with a gas membrane, it was clear in 2012 when the building was demolished that there was a fault. Is there a benefit of them waiting until last minute? There's never a benefit in waiting till last minute from a legal perspective. You never ever, you raise, the later you leave it, if you think about it, if you're the pursuer, the later you leave it, the witnesses will have left, they'll have moved on. Their records will possibly be lost. They may be on 2 computer systems ago. Recollections will be less reliable from those witnesses who are involved. And I suspect probably maybe in Midlothian, it might have been perhaps an understanding of the law at the time as to when the loss occurred, might have led to the wait and see approach. Let's just see how much this is actually going to cost. But generally, if you have a claim, you raise it as early as possible. And I can guarantee you, there's one thing that gives all litigators and everybody in our team is exactly the same nightmares. Literally, we all have time bar nightmares where you wake up and you think you've missed a time bar. It's the most horrible situation. And it's, if you can imagine, it's a lot worse for a client. So, but obviously, if you're the designer, you're going to be sitting thinking, thank you. They're but for the grace of God. Yeah. Any other questions?
Just on that, just kind of the doom and gloom consequences of Midlothian, we've seen it where, because effectively parties aren't being given the time that they need to work out who's at fault specifically and who to sue, there tends to be a bit of a scattergun approach and sort of suing multiple parties that could be potentially on the hook. And we've kind of heard stories where smaller practices have effectively, because they're receiving these multi-million-pound claims just to protect the pursuer's position, can't then afford the insurance premiums thereafter that result from that claim being raised. So probably why kind of parties tended to wait before Midlothian was because they wanted to be sure that they were suing the right party, and the consequences of that happening would effectively be worth it. But we just don't have that luxury anymore, unfortunately.
I suppose the final account would have become almost the conclusion of your quantum report as well. You know, the longer you have to wait, that the consequences become clearer, whereas you're now having to raise an action before you know. Sometimes what you have to do is raise an action for a declaration that there's a breach, and that's enough to stop the clock. And that's just because you just don't know what the quantum's going to be, and you can't know at that stage. And that was the decision. That was our case in Shetland Islands Council against Highlands and Islands Airports Limited. That was, we were acting for Shetland in that, and that was what was done to try and protect against time bar, and that was found to be competent. Any other questions?
I just have to say that sounds a bit scary now. So is there any way that, especially if you're in a small practice, can you, other than, should you put in the net contribution clause into the initial contract? Is that the best way to get out of these potentially super damaging claims? Or, I mean, other than not making any mistakes, which is not really realistic, is it? So
anything you do in your contract to limit your exposure is definitely very, very beneficial. But ultimately, you can't stop anyone from raising a court action against you. I think probably what's happening in Scotland at the moment is I had a case I was advising a contractor where they were sued by a JV partner for something, and it was on the back of that they were pulling out of tendering for 2 major UK frameworks because they don't tender for anybody. Their policy is they don't tender with anyone who is suing them. And I had to explain to them that, listen, this is not a normal world. Normal rules of engagement don't apply. Raising a court action like that is quite often just seen as a precautionary thing, so you don't lose rights, rather than a considered decision to sue for a loss. And remember as well that whenever you raise an action by raising and serving it on a party that's stopped the clock, you don't have to actually lodge it for calling for a year and a day. And Stephanie and I, we've got quite a few cases that are trundling through that year period where investigations are being concluded before the decision is made as to whether or not to proceed or which parties to proceed against. And some parties, the action will not be continued against them because there perhaps isn't a strong enough case, or there's a greater clarity as to which party caused the loss. Mm-hmm. But as Stephanie says, you've just got to, it may be scattergun at the time, and that is competent, but it can have some pretty serious consequences for some parties, unfortunately. And we know of one that has gone out of business because they couldn't get the PI cover. In a world when there are fewer PI providers in the market, it's a hardened market, and they are trying to exclude cover in every way. They are excluding cover in certain areas to try and reduce their exposure.
Yeah. But yeah. Better get some good advice on the initial contracts is my conclusion from this.
Definitely.
Yes.
On that note, our key contacts are just on the slide there. So if anyone needs any advice on putting together appointments, then our details are on the slide there. So
yeah. Okay, so are there any further questions from any of the audience, or should we just conclude? I mean, there was so much information in there. Again, thank you so much, Stephanie and Manos. It's obviously it's hard to take it all in if you're not immediately, involved in a similar case. But I guess it's good to get the kind of general gist of things and then just go back to you if any particular advice is needed, probably.
I think the thing is, if you want to take away some simple messages to carry in your head, it is that in relation to design and specification and advice to some extent, the date when the 5-year clock starts ticking, if someone accuses you of having got it wrong, made a mistake, of being negligent, just immediately think that it's when was the contract entered into for the delivery of the execution of my design, and that is probably the starting point, or close enough to the starting point for the date of loss. And is that more than 5 years ago? But always remember as well, just more important than anything else, and that's carry that in your head. But more importantly, if someone does make an allegation against you in relation to defective design, first thing you must do is notify your professional indemnity insurers, because failure to notify could leave you uninsured and that we do come across situations where that is exactly the position adopted by the insurers, where you fail to notify them, you've prejudiced their position. So even if it's a threat, it's better to negotiate, it's better to notify on a precautionary basis, because it won't put your premium up generally. Your broker will best to advise you that, but the principle is generally it shouldn't put your premium up, but it does protect you in the event that it does, maybe even 2 or 3 years down the line, develop into a proper claim.
Okay, that's helpful. Great. Okay, so I don't see any other questions. Just let me thank you again, both of you. That was really super interesting, and we hope to maybe get back to you at another stage with more questions. But thanks for now, Stephanie and Manos, and for all of the attendees. So we're going to put up the recording of this event on our website in case you missed parts or you want to just go back and have a proper read of it all. and that's going to be there in a couple of days' time. And future events, tomorrow there's a design conversations event 1, does Glasgow need tall buildings is the question. So there's going to be a discussion. I think it might be maybe near on capacity, but just go on our website and have a look. And then we'll be offering walking tours with the Glasgow Doors Open Day in September, but that still has to be confirmed when and where exactly. So just have a look at our website. And thanks for now and goodbye. Take care.
Much.